Any mention?
It is your lordship's lordship. Back to mention item number 8. Conducting item number 8, my lord.
You are for?
I'm for the petitioner on behalf of Mr. RB.
It's ready for hearing.
My lord, it's ready for hearing. Conducting counsel has some personal difficulty. Kindly have
Mr.
this.
Sen?
No, Mr. RB Phukan.
RB Fukon?
Raka Vijay Phukan.
After when? 1 month?
After 2 weeks, my lord.
Okay.
The interim may kindly be extended.
Interim, yeah, objection, interim continuing.
My lord, may be taken up by the next date, my lord, this matter.
Okay. Interim shall continue.
Awesome.
Please, Lordship, I beg to mention item number 9. Learned CGC is on sanctioned leave, Lordship.
Yes?
Learned CGC is on sanctioned leave.
Don't leave. Yeah. 2 weeks, yes.
Oblige, Lordship.
Oh, we have objection? No.
No objection, my lord.
Item number 1.
May it please, Your Honor.
Yes.
Your Lords. My Lords, this matter can be disposed of, my Lord, by directing this CPC AO to accept manual returns, my Lord.
Who's CPCO?
This is Centralized Processing Center.
Central Center. No, who's the designation?
Designation is Assessment Officer, Centralized Processing Center. My Lords, because ITH's order is directed against AO CPC/CIT appeal, my Lords. And my Lord, what could have happened, my Lord, is that even though the language is a little ambiguous, in my humble opinion, my Lord, the ITH's order was if the SSC files return, I think ITH meant physical return, my Lord. That's what.
So that is exactly why he came here, because you're not accepting the physical returns.
My Lords.
So if that is eventually, this happened before in any other case.
Yes, I have found
lords,
3
my
instances below.
That is what, yes, you guys show. That is why we're seeing how is it possible. Yes. So we'll direct the
AO CPC, my Lord.
it is the Central Processing Center.
Centralized Processing Center.
CPC.
CPC, my Lords.
AO.
AO.
Let us see.
This is from the Delhi High Court. Please look at the facts at para 1 first.
Yes.
That the petitioner has filed the present petition for direction to the respondent to accept the petitioner's return of income for assessment year 17-18 manually, since the petitioner has not been permitted to carry forward the business losses because of programming difficulty, which precludes the petitioner from claiming it while filing its return online in form ITR 6. Then please turn to page 4. The pagination is at the bottom.
Yes.
Para 7. Once it is abundantly clear that the amendment in section 10AA takes effect only from so-and-so date and would apply from AY 1819, it is clear that for all AYs prior to 1819, the law explained by the Honorable Supreme Court and so-and-so would apply. This is not even disputed by the revenue. If the legal position is therefore clear, then it becomes incumbent on the respondents to correct the e-filing software to enable the implementation of the decision in so-and-so. In other words, it will not be open to the respondents to contend that the e-filing software will determine whether an assessee can carry forward losses of ineligible unit. The software will have to be changed to comply with the legal requirement and not the other way around. The issues arising from transiting to the online system have been dealt with earlier by courts. In each such instance, when faced with the situation of a software glitch that prevents an assessee from filing a return or claiming a benefit, the courts have repeatedly had to permit the manual filing of return claims and have directed the respondents to act on such manual filing of return. One such instance is so and so. Then please see para 11. Accordingly, a direction is issued to the respondent to either accept the manual return of the petitioner or alter the software to permit it again file online its returns claiming the carry forward losses of its ineligible unit. But there's another judgment of the Madras High Court, which was just under reference here.
That
Tara Exports, my lord.
do you have to recalibrate your software?
My Lord, as it is
They
the
must be having some kind of window,
obviously, my lord, the
because
human
if these things are happening, that means they must be having some kind of
intervention is possible, my lord, because if some changes
Yes, some
happen,
changes in how
if Parliament
human-
makes some changes under Finance Act also, my
Yes,
lord,
how-
so
how-
this
how
has
we
to be
must
recalibrated,
incorporate
my
that.
lord. Yes, my lord. But the scope has to be there, my lord.
As in
We'll
this
pass
one,
orders then.
Yes, my
Lord.
lord.
Take up other matters first.
Item number 2.
highly pleasure.
Hello, my lord.
My lord, we are entering appearance on behalf of the respondent number
Let the
1.
file come. Yes, slow number 1.
Yes, my lord.
That's what you-
And we'll be filing.
Yes, so we'll condone the delay.
Yes, 70 days, no objection, my lord.
Order of acquittal.
My lord.
Yes, my lord.
Yes, Mr. P. Owen has had an appearance today on behalf of respondent number 1. Who's there on behalf of the state?
The state.
Yes. Ms. S. Gupta is present and Ms. S. Gupta. You are additional senior government advocate or what is your designation? Additional public prosecutor has been accepted on behalf of number 2 and this complete stop. This is an application. Sorry, first this is an application is for condoning delay of 17 days in filing an application for leave to appeal against judgment order dated judgment order of acquittal dated 29 and 29/1/2025 passed by the Sessions Judge Clariat in Sessions case number 88 2022. Stop. The delay, Mr. Yobin, who is present behalf of respondent 1, sorry, has no objections to the prayer for condemnation. Accordingly, the release condoned and the application for leave to appeal
We have next week.
listed on next date.
My lord, they have the memo of appeal. They have served as a defective petition.
Memo appeal
Yes, my lord.
between you and the
Yes.
yes, first registry to Daira is also yes. This and some
Obliged.
this case is disposed of.
Hearing, item 6.
Also, in this matter, the respondents have not been appearing. The last occasion also they were not here.
What to do?
Last chance may be given, my lords.
Last time we'll give. Substantial questions of law framed. They have
Yes,
not
my
come
lords.
forward.
Already
Framed.
framed, my lords.
Yes, none appears for the respondents. None appears for respondents. Stop. It is noted that on the last date, that is 13/5/2025, there was no appeal on behalf of the respondents, and dates prior, that is on 27/2/25 and 25/25. Stop. In the interests of justice, last chance is afforded, failing which on the next date the matter shall proceed ex parte against the said respondent.
Most obliged.
This after 2 weeks.
Item number 7.
Yes, Mr. Dasgupta.
Yes, I have submitted this suggested question of law proposed.
Dr. Mosiga, you have some objections to the substantial questions of law framed.
My lord, in my humble submission, there is no substantial question of law involvement.
My lord, I have specifically mentioned in the question number 1, what are the material evidence has been ignored by the tribunal. And those are the materials I have given in the appeal petition also 5A to Q, page 25 to 42. These are the documents mentioned in the order in original and in shocos. It was not addressed, though raised. So, if no substantive question can be raised, then it can be remanded back to tribunal for deciding the issues which was not addressed with a time frame by this honorable court.
You say also it is in disobedience of the direction dated so and so. Where's this matter? What's this case? 1992 3 SEC. What is this? What is this? In para 2, see the judgment you cited. What is the directions in that said judgment?
This is only for reference, my lord. This is only for reference. And key facts overlooked evidences. Seizure inventory, my lord, kindly see page 59 of the appeal petition. It is
Seizure was done which year?
2014, 27.
So now
11 years. Yes.
What's happened to the gold?
Gold, it was as per direction of this court, it was kept in the locker.
90 kilos.
No, not 90 kg, only 4 kg, 4
4
kg.
kilos.
90 kg I have purchased before this seizure.
Invoices you showed.
Yes,
That
yes.
he purchased 90 kilos of gold.
That is I have purchased before the seizure for the last 3 years as per books of accounts. I purchased. And I have sent from the stock. I am a reported jeweler in Manipur that was recorded in order adjournment para 9.
Oh, yes.
Yeah, and so from the stock I have sent 4 kg.
What did you show from 59?
This is an inventory, my lord.
You say this is not taken into consideration.
Yeah, this was not. That is recorded unmarked gold with no origin proof. The department has not proved it is a foreign origin. So question of smuggle does not come. First they have to prove foreign origin. Here, my lord.
How do you ascertain foreign origin? Suppose the gold has been melted, those biscuits have been melted, and then
Yes,
By
it is
purity or
melted
by
as per
marking?
procedure, as per normal procedure.
What's not by checking?
Yes,
purity?
that was department has got nothing to. They have agreed that for melting, no permission, nothing is required.
No.
So-
How do they check the purity then? By checking the purity, how do they know that's foreign gold? See, the gold biscuits were triangular in shape.
Yes,
and seized
yeah.
and bono marking. Representative sample has been drawn from each biscuit, weighing 4 grams to 7 grams each. 26 pieces, yes.
Here, yellow rectangular mantle biscuit believed to be gold of foreign origin. So there says the gold biscuits were rectangular shape and bore no marking. No marking was there. Reference samples have been drawn from each biscuit 4 to 7 grams each, and it was accompanied by document at page 60. Duplicate bill of Magna Projects Private Limited, Kolkata. That was seized by the RPF under section 145 and 46 of the Railway Act, and thereafter handed over to the customs. So, seizure inventory show.
Yes.
So plain reading from this, it is seized in Dimapur railway station. It is neither a port nor an airport or even a border, but no marking. 3 pieces of Magna Projects documents are there. Now, my lord, second, Shawgo's notice 27G confirms the gold purchase of exceed 90 kg.
They were recovered from one person only. One person from the person from one person only was covered.
Achha. Then, my lord, SCN para, this is 142, 143.
Where are you reading? Page.
Page.
Yes.
That is 27G. Total amount claimed to be spent to procure the gold by the unregistered individual associates entity of the Rajkumar Angamishi during financial 12, 13, 13, 14 and 14, 15. That is, my lord, total I have purchased 3 crores 14 lakh 77,000 750. Then in financial, at page 143, financial year 2013-14, I have purchased 18 crores 10 lakh 75,000 519, and 14-15, I had purchased 1 crore 75 lakhs. So, in spite of such huge transactions, they could not produce before the custom officers any record, or that is, they have recorded. So, bank statement, that is one. Then statement of the SCN, para 1.3 to 17, page 120,
One second.
before the RPF.
What about that in para 143, CB? Mostly so-and-so which are similar to gold seized in some case clear they were smuggled ones.
My lord?
It is imperative that foreign
Yes.
markings in gold biscuits have been removed by application of heat. In instant case, evident RK so-and-so had removed the foreign markings before transportation and handed with the purchase invoices to hoodwink the law enforcing agencies. Yes. So which part of the materials do you say the tribunal did not?
That is what that I have purchased 27
Was that
90.
examined by them? What remains unexamined?
This is the books of account. They have not taken into consideration. They should give some.
The books of accounts.
If this is books of
There's no
account.
finding on the books of account in the orders you've impugned. Any finding or not arrived at?
No, nothing.
No finding.
No finding.
That's correct, Dr. Musika?
That's not correct, ma'am.
That's not correct.
My lord, may I take a lordship to the order, my lord? The order part with the title.
How do you say that they are examined?
Yes,
The court
that
does
is
want
not.
to see that, since whether you are praying now, okay, fine, there might not be substantial law, it might be a question of maybe mixed fact and law with regard to appreciation and with regard to the factual aspect about the status of the gold. Now you see F at 142. If you say it's not been examined, read para F.
F.
Page 142. Yes.
If lordship examines this order, the impugned order, but that is not the impugned order, that is the order passed by Commissioner, my lord.
Yes.
The tribunal order starts at page 189. Against which they
Where's the
come.
finding?
My lord.
No, because he's taking us there to show that this is the amount of gold he's purchased in those whatever financial years.
Right.
So his submissions they were never taken into account. The
But that
invoices
has
not
been done by-
examined,
that
and
is-
so they were bona fide gold procured from some entity to be made into what?
189 tribunal order.
Order starts at 189, my lord.
Yeah.
Though this is a long order, if I lordship permit you to read this order, my lord.
The whole order. So show the relevant part for the finding on that aspect as regarding the invoices, whether
Invoice,
it
yes.
could relate with the evidence tendered by the
page
by
20
the petitioner, and whether that is substantiated by whatever invoices or something that he produced before the appellate tribunal or before the custom tribunal.
My lord, para 13, my lord, page 202.
Page
202.
yeah,
You will have to permit to read.
para 13.
Para 13.
Yes.
From the material evidence discussed in foregoing paras and the narrations, the following emergence can be summarized that on 25th August 2014, the Railway Protection Force personnel at Timapur Railway Station recovered 26 pieces of gold biscuits from the possession of T. Santibala Devi, R. K. Rojita Devi, kept concealed in their waistline of jeans pant petticoat, collectively weighing 4,334 grams approximately. The gold biscuits seized were in the form of rough biscuits without any marking inscription or any number and were not supported by proper documents. Each gold biscuit weighing 166 to so-and-so grams were alleged by the investigator to be similar to the gold biscuits smuggled from Myanmar and were not conforming to the locally available gold biscuit weighing generally in between 116 to 117 grams. Admittedly, the foreign markings available on the said goods were removed by application of heat before transportation of the same. 13 pieces of the biscuit were kept concealed in the waistline of jeans pant of T. Santibala Devi and another 13 concealed inside the waistline of the petticoat of R. K. Rojita Devi. The said goods were being carried from Imphal to Kolkata without any sales tax challan, service tax bill, etc. The photocopies of 3 invoices said to be issued by Magna Project Private Limited, Kolkata to Rajkumar Angangbi Singh, Imphal, recovered from the 4 carriers of gold, was found to be fake and forged as...
The photocopies of 3 invoices.
My lord.
Said to be shared from where they said they bought the gold.
My lord. Was found to be fake and forged as the goods sold under the said invoices were found to be in the form of 1 kg bar as well as in the form of smaller biscuits. Therefore, the photocopies of the said invoices recovered produced were not relatable and do not correspond to the said recovered 26 pieces of gold. Gold bars, biscuits, or coins are normally sold in polished, finished condition having logo, inscription, number, SAS, name or purity marking, etc. for identification. However, nothing as such were there on the recovered goods, nor reason for the same could be explained by the carriers. The said invoices were for sale, transportation of goods from Kolkata to Imphal, whereas in the instant case, seized confiscated gold was being transported from Imphal to Howrah, Kolkata. Also, no consignment note, challan, nor any authority letter in support of the transportation of the said gold biscuits was produced by any of the 4 persons, namely Templar Singh, Samsung Singh, Santibala Singh and R. K. Rojita Devi, travelling together at the time of interception. The essay report of the seized gold biscuits furnished by the Indian government Mint Kolkata is shown higher purity than what was mentioned in the recovered invoices, thereby evidencing that the copies of the said invoices did not
That's why I asked
correspond.
this question, the purity.
My lord.
Yes.
Now, my lord, on 9/9/14, R.K. Angang Singh produced another 5 sets of invoices number so and so, dated so and so, all issued by Messrs. Magna Projects Private Limited, Kolkata, in the name of Rajkumar Angang Singh to justify transportation of the said 26 pieces gold biscuit. He had earlier stated that the purchase invoice number so and so were handed over to the carriers without any ulterior intention, as they commenced the journey hurriedly, and the actual documents were these documents which he had submitted afterwards, that is the aforesaid 5 purchase invoices. It is thus evident that the documents produced by the persons from whose possession the said goods were recovered are also admittedly by the appellant do not relate to the seized gold biscuits, and the documents produced later were submitted as an act of afterthought. The 5 purchase invoices produced by R.K. Angang Singh on 9/9/14 to justify transportation of the 26 pieces gold biscuits were all purportedly issued by Magna Project Private Limited, Kolkata, in the name of R.K. Angang Singh. Investigations revealed that there was no reference of purchase invoice number so and so in the ledger of Magna Project Private Limited. Sri Anand Kumar Agarwal, accountant, Mrs. Magna Project Limited, Kolkata, stated that invoice number so and so dated 29/4/13 showing party's name as Rajkumar Angang Singh in the matter of sale of 8 kg gold valued at 2.26 crore was not genuine and was a fake invoice, as the actual said invoice was rupees 3 lakh and issued in favor of Milan Kanaka Saj Jeweler of Kolkata. It therefore can reasonably believe that the tax invoice number so and so issued by Magna Projects in the name of Rajkumar Angang Singh for sale of 8 kg gold and which was produced by R.K. Angang Singh on so and so while claiming the seized gold is a manipulated and a void document. Therefore, it is apparent that Rajkumar Angang Singh had produced falsified document in order to justify transportation of the smuggled gold. R.K. Angang Singh, in the writ petition filed before the Honorable High Court of Meghalaya, had claimed that the gold biscuits under seizure pertained to stock of gold purchased by invoice number so and so dated 28/7/14, issued in favor of R.K. Angang Singh. Number so and so dated so and so issued in favor of R.K. Angang Singh, issued in favor of Ranjana Devi. He has thus contradicted his own statement subscribed before the customs officer on 9/9/14, wherein he claimed that seized golds were consigned from the stock pertaining to invoice number so and so, so and so, so and so. Sasikant Sinde, director of Magna Projects Private Limited, Kolkata, specifically stated that Magna Project Private Limited, Kolkata had no business dealing with R.K. Angang Singh during the financial year 2014-15. In support of his claim, he had submitted ledger account of
again. Shashikant Shinde,
Shinde, director
who supposedly issued
the invoice and sold the gold to them, my lord.
So that's not our invoice.
It's not their invoice, my lord. That is what earlier the manager also said, my lord. In the
Yes.
Anand Kumar Agarwal, accountant, also said the same thing, my lord. Sasikant Sinde, director of Magna Projects Limited, Kolkata, specifically stated that Magna Project Limited, Kolkata had no business dealing with R.K. Angang Singh during the financial year 14-15. In support of his claim, he had submitted ledger account of Rajkumar Angang Singh and R.K. Sonia, which made it evident that invoice number so and so, so and so, so and so dated, produced by R.K. Angang Singh while claiming the seized gold biscuits, too were fabricated and void. The factual contents of his statement is also supported by the statement of Anand Agarwal. Thus, even though R.K. Angang Singh has produced 3 different sets of purchase invoices to claim the ownership of the seized 26 pieces of gold biscuits on 3 different occasions as indicated in the following table, there is nothing to establish on record that even at least one of the sets of invoices tendered were genuine and could cover the impugned sale and possession of the seized confiscated gold. The onus cast upon the appellant to establish illicit acquisition, possession of gold under section 123 of the Act is thus not discharged by the appellants. While the appellants, by virtue of their books of accounts, have stated that they are large-scale gold dealers having procured nearly 43 kgs of gold valued at Rs 13 crore from Kolkata during 2013-14, on the other hand, they ascribe their failure to manage invoices and other records of satisfactory link the seized gold with the various sets of invoices tendered or any illicitly produced evidence by them as to be on account of lack of manpower. Thus, it belies logic. If gold over 10 times the quantity of seized gold can be duly recorded in their books of account, what prevents it in satisfactorily demonstrating proper and legitimate accountal and documentation of seized goods, if at all it ever existed? The said argument of shortage of staff is thus a mere ruse to cover up the colossal failure. The statement tendered by Anand Agarwal, though retracted, is an important testimony, as it is not only contains wealth of information but also corroborative with the actual testimonies of others like own director Sasikant Sinde. Also, given the fact that Anand Agarwal thereafter, post-retraction, did not make himself available to give his testimonies afresh, is evident of the fact that the impugned retractions were a mere afterthought and hence holds no legal force. So, my lord, we may skip. So, basically, the documents what the commissioner as
Has
well.
been examined. How this has not been examined? Yes, sir, that's good.
My lord, my statement SCN para 1.32, 1.7, 3.1 to 3.5. That is the accused person before the RPF and the customs. Never they said that is a smuggled goods.
No, that's a question. The onus is upon you to show that that it is legally and bona fidely procured, and you're transporting it from Impal to Kolkata. The thing is that now they've gone through the invoices that we first invoice that you've given. You say sorry, there were wrong invoices due to hurry. We could not give, and they don't even produce the second set of invoices, which has been actually as per your contention issued by Magna Projects. Now they said we never issued it. I don't have any business dealings with them in that year. So
they are only after invoice this and this post seizure, but they are not coming whether it is how it is they are established. The tribunal has not considered how it is foreign origin, and question of smuggle come later on. India imported thousands of gold, imported gold from the outside, and all these are in circulation. Apart from the family golds are also finding the gold per se is not a contraband item.
oh, correct.
Yes.
But the thing
So,
is that the onus is upon you to show.
so they have not.
contraband.
So
Simple as
tribunal
that.
also has not trust. They are only ordained original. They have just confirmed. This is only they are taking this post seizure. This memo is not correct. This invoice is not correct. That is for these things.
Now you see, you come
So-
within the four corners of what your appeal will contain or what you can challenge at this stage. It's a second appeal, correct? So that is why you have to give the questions of law, which the court will see that you determine yes, there is some substance in what you have submitted with regard to the questions of law, where there's been some error or has not been addressed. Correct? That is what. Now, from the facts of the case itself, you're arguing on facts only. It's not a question of law at all.
No, law also I will.
Now, law will
Yes,
follow.
yes.
Fine.
My lord, only one aspect. My lord,
Yes.
gold is covered by section 123 of the Customs Act, my lord, where there is a reverse burden. Burden is on the person from whose possession the gold is seized to establish, my lord, that it is this is
That
a
is what
illicit
the
gold.
court is saying.
My lord.
And the onus is upon the
appellant.
to show that the gold is not contraband.
So I have discharged
and
my.
then you have discharged it, and they are not satisfied. You have shown invoices which have not been. It is not. They cannot substantiate the amount of 26 gold biscuits or 26. What is that? 26 biscuits. Oh,
20,
whatever.
26
26.
gold
Whatever,
biscuit.
yes, whatever.
Whatever it may be. Yes.
Yes.
So this
what else you have-
123.
What other submission do you have to make?
That 110. This is not a seizure according to me. RPF seized for under the Railway Act. Then they have taken over. So it is not at all a seizure. Reasonable belief is not there under section 110(1) of the Customs Act. Custom has no reason. Even they do not know whether it is a gold or not as per inventory.
What do you mean you don't know whether it's gold or not?
They say that it is a rectangular in shape and it is believed to be gold.
No, at that point of time, might be
Acha.
not gold, but sometimes it's tested, it's found out it's just
So
gold, it is
reasonable.
how you know.
So one question may be framed. There is a perverse order that I will justify. There is a perverse order because they have not taken into consideration the relevant records. This order and original also they have not taken into consideration tribunal also. In spite of direction by this honorable court and the Supreme Court. Supreme Court says all the points has to be discussed. All this.
You have discussed on the point, the main points on the.
No,
the
tax issue they have not discussed. Tax issues they have not discussed. They are just bypassing it.
The what issue? The core issues.
That is the foreign origin. Nothing, nowhere, no, they could not produce any document
There's
for
a
foreign
finding
money.
there
So
that the purity of your gold is.
no, their purity, it is falsely they have recorded. Yes, as per essay report, my lord, I will tell you there is bureau standard. 99, as per essay report, my lord, it is there. Purity is less than international standard. Essay report is at page.
But may I just May I place one decision, my lord?
Yes.
Place one decision, my lord.
Yes.
What is substantial question of law, my lord?
What is substantial question of law in these kind of matters?
It is SCD, my lord, at 125.
1 second.
Chandana Impacts, my lord, 2011. I'll take a lot to para 13, 14, 15.
Yes, in the some other matter also, I think we had same thing with regard, that 14,
Para 13 onwards.
para 13, yes.
I'll read, my lord. As stated above, the appellant have framed in their appeal before the High Court as many as 7 questions as substantial questions of law. It is manifest from a bare reading of the 6th question, which B to G, repeated in this appeal, that none of the question can be said to be a substantial question of law, inasmuch as they do not proceed on the premise that the decision of the tribunal on the issues raised therein is perverse, in the sense that the findings of the fact arrived by the tribunal are not based on the material placed before it, or that the relevant material has been ignored by it. It is tried law that a finding of fact may give rise to a substantial question of law, inter alia, in the event the findings are based on no evidence, or while arriving at the said finding, relevant admissible evidence has not been taken into consideration, or inadmissible evidence has been taken into consideration, or legal principles have not been applied in appreciating the evidence, or when the evidence has been misread. In Hero Vinod versus Sesammal, referring to the Constitution Bench decision of this court in so and so, as also a number of other decisions on the point, this court culled out 3 principles for determining whether a question of law raised in a case is substantial. One of the principles so summarized in Hero Vinod is the general rule is that High Court will not interfere with the concurrent findings of the courts below, but it is not an absolute rule. Some of the well-recognized exceptions are that the courts below have ignored material evidence or acted on no evidence. The courts have drawn wrong interference from proved facts by applying the law erroneously. The courts have wrongly cast the burden of proof. When we refer to decision based on no evidence, it not only refers to a case where there is a total dearth of evidence, but also refers to any case where the evidence taken as a whole is not reasonably capable of supporting the findings. Tested on the touchstone of the said legal principle, we are of the opinion that the order of the tribunal, when the material referred to by the commissioner in his order has been extensively analyzed, does not give rise to the 5 questions proposed by the appellant in this appeal as a question of law, much less substantial question of law. It would be a repetition that none of the said questions seek to challenge the findings of the tribunal or that of the commissioner on the issue raised in the question as perverse. It is not within the domain of the High Court in appeal under section 130 of the Act to investigate the grounds on which the findings were arrived at by the tribunal, the final court of fact. In that view of the matter, we do not consider it expedient to remit the case to the High Court insofar as these 5 questions are concerned. So, my lord, broadly the parameters are, if there is no evidence, my lord, or evidence has been, there is a blatant misappreciation of evidence, then only a substantial question of law will arise. Here, what has been submitted?
No, most important that the burden is upon him.
Burden
is charge it before both the the rule and the commissioner. So,
and in case of they could not produce this foreign origin, then burden lies on them, not me. If they could not produce this, they have no evidence that is a foreign.
Just one thing, Mr. Dakupta, suppose you had produced the correct invoices showing that, and still they maintain that is foreign origin, then it's upon them to say that it was bereft of markings and so it is foreign origin. But in your case, you did not have anything to substantiate that. This first you produce invoices which you say disregard them because we in a hurry they were sent, and second that you produce invoices which has been questioned by the people from where you said you bought the gold yourself. So on what more evidence does the tribunal need? There's nothing. Apart from that one point, you say that it's not been proven beyond reason doubt that it's not foreign gold. That's all. What remains?
So
you want to prepare further, or we'll reserve it for judgment?
No, this essay report, this is there, my lord, at page 125. All these are below standard. This is international standard.
No, the most important fact is that you could not, you didn't have the challan, you didn't have the invoices, you didn't have, the which you
Challan to
to
I
show
have,
that this amount of this gold,
I have melted the gold from this existing stock. So
My lord,
this is
very fact that my lord, gold coming from Manipur going to Calcutta, my lord.
that reasons everything I have explained, my lord.
were taken to Calcutta to make
For a
coins.
small, so for a smaller quantity of this
make jewelry.
coins to use in the festival, Meghna festival in Manipur.
Which festival?
These are fake bills, my lord. He procured just to justify. Because apparently these are smuggled goods from across the border.
We're not here. We're sitting in appeal. Again, we'll reiterate that's all. We have to look at any perversity, any this which will otherwise concurrent findings. This court will not. We'll give you one more opportunity to bring some authorities before final orders are passed. Okay. Yes, Mr. N. Gupta, please for 2 weeks time to prepare to bring some authorities on that aspect when you said. Otherwise, yes.
Much obliged.
Any mention?
Item number 24, it is in the hearing list. It may be taken after a week only.
44.
24. Okay.
Mr. Kharmi has objection, I think.
No objection. I have no objection.
What's the matter about teacher matter?
Teacher's matter. It's a promotion matter.
After?
After a week.
2 weeks, yes.
No objection.
Yes. Yes.
Please, Your Lordship. Your Lordship, beg to mention item number 28, Your Lordship. Sorry. It's a joint request, Your Lordship.
Next week. 2 weeks, my lord.
Yes.
Objection.
I beg to mention item number 23, Lordship. 23, Lordship. 2 weeks, Lordship.
Matter?
No, Lordship. This is sub compensation, land compensation.
No objection, Your Lordship.
No objection. What about other respondents?
Objection, sir.
2 weeks is.
Obliged, Lordship. May it please Your Lordship. Your Lordship, I beg to mention item number 12, Your Lordship. 12 to 18, Your Lordship.
12 to 18.
The connected matters, transfer matters, Your Lordship. The Advocate General is not available today, Your Lordship.
No objection, Your Lordship. No objection, Your Lordship.
Yes. After 2 weeks, okay.
Your Lordship, item 11 also is connected, Your Lordship. This is also a transfer matter.
Yes.
Much obliged, Lordship.
You're there also, Mr. Mansoori?
I mean 11, man.
Very good, yes.
Obliged, Lordship.
Lordship, I beg to mention item number 26 of the main list, Lordship. Lordship, I'm praying if this matter can come after 2 weeks, Lordship.
Why?
Some difficulty on the part of learned senior, Lordship, today.
Argue the matter.
Learned senior, Miss Apol is leading, Lordship.
Mr. Paul?
Miss Paul.
No objection, Your Lordship.
But the road construction is being held up.
Your Lordship, the only with regard to the petitioner's land, otherwise the rest is continuing, Your Lordship. It can be.
Hello.
Yes, after?
2 weeks, Lordship.
You can't keep on enjoying this, yes.
Obliged, Your Lordship.
Lordship, item number 21, Your Lordship, on behalf of A.H. Karwala.
My lord, he's sick.
Who's sick?
That
A.H.
Karwala, Lordship. Joint request, Lordship, no problem, Lordship. Yes.
Okay, 2 weeks, yes.
Lordship.
Lordship, I beg to mention item number 25.
Yeah, objection?
No objections, Lordship. We received prior intimation.
Mr. Eubin is here also?
My lord. My lord.
Okay, 2 weeks or 1 week?
2 weeks.
Okay.
Are you obliged?
May it please, my lord, I beg to mention item number 22. The conducting counsel, Mr. K.B. Bhattacharjee, has some difficulties.
Mr.?
K.B. Bhattacharjee.
What's happened to him?
Has some personal difficulties, my lord.
He's not interested in practicing anymore.
No, my lords. My lords, he has some personal difficulties. He'll be available on the next date.
Very erratic now in the appearances. Yes, no objection? Yes.
Nice, my lords.
Supplementary. 19, ready, 19? 19 ready, taken up today. Yes, Ms. Emruchan.
Your Lordship, I'll pray for some more time, Lord.
You bring some more time. We thought at least, you know, we will be saved and have some matter to. (19, 20) are connected.
Yes, Your Lordship.
When can you argue? Because the Advocate General is not here also.
Your Lordship, Mr. Sen will be arguing the matter.
Mr. Sen. Where's Mr. Sen?
He's here, Your Lordship.
You're still not ready on the matter?
No, Your Lordship. Let it come after 1 week.
With regard to a promotion?
Yes, Your Lordship.
The 20 matters. That's why this code is. We'll have it after 1 week. But please, No more adjournments. At least we'll finish off these two matters. Yes.
Obliged, Your Lordship.
Supplementary list item number 1.
What is this, Mr. Qureshi?
Lordship, in this case, the Lordship has given a direction to the director to dispose of to take a decision in accordance with the law.
Decision regarding?
Regarding the Constitutional Managing Committee. Because almost going to be 2 years, the decision is yet to be taken, though there was a hearing between the parties also. But now the order was passed in the month of, it was passed on
March.
5th, in the month of March. But yet the decision is yet to be taken. 5th March 2025.
There's no time frame given anyway.
Time frame was not there, but there was already hearing was there, but they said the matter
Has the hearing been done before the respondents?
Yes, hearing was done. After that, they said
When was it done?
It was done in pursuance to that 15 April. 15 April. 15 April. Now we approached the director. He said we have taken a decision, but the file has gone to the higher authorities. But in this case, the direction was very clear that it is the director to take a decision, not to the higher authorities. Why the higher authorities are interfering into the matters?
It's gone to higher authority.
Yes, it is annexure, Lordship, annexure 16.
Yes.
It should be in accordance with the court order only. It said in pursuance of the government notifications.
Well, next year 16.
As annexure 2. And page 16 also. Page 16. Page 16. The first line only shows that in pursuance of the government notification wide order dated so and so 29 March 2025 and in compliance with the order.
So here it's been done.
Yes. So once
the way you see it's gone to higher authority.
This is the letter by issued by the higher authority. Actually, the court has not directed any of
He's the correct one. He's number 2. Number 1.
No. Number 2 is the director.
He is the director.
Director. But this letter has been issued by the commission, by the secretary, the Secretary Education Department.
No.
Yes, Lordship.
Page 16.
Yes. In pursuance of the government notification, it was issued by the secretary. By the secretary.
Doesn't matter. I mean, they're taking.
But Lordship, the decision has to be taken. Director has taken a decision according to we have approached. He said the file has been put up to the higher authority.
The respondent, he is there also, number 1.
Number 1, he is there. So Lordship.
Okay, heard Mr. M. F. Qureshi. Issue notice returnable in 2 weeks. Self taken within 3 days. Yes.
Must be.
Daily list item number 1.
As per your Lordship's order, your Lordship, we are submitting the name of one more independent.
Yeah, Jindal.
My Lord, we've also taken the liberty of preparing a small list of 2 names, independent persons, for Lordship's consideration.
From Mr. Kharsat, where's Mr. Dingdo is not here. No. Where's your suggestion?
Give it to the court.
No suggestion? No suggestion. From your side, no suggestion. Sure about that. Don't object later on. That we were not given opportunity of, of supplying our names.
Extra. I think I have on it. Oh, you're asking these?
No other names, Mr. Jindal?
My Lord. Because one is a esteemed member of the bar, and he's been involved with religious activities on and off for quite some time. The other, my Lord, I'm
talking about a social entity, not a professional. You get what I'm saying?
My Lord. For the moment, these were the most suitable, at least in our very humble opinion. The other member, my Lord, the second name on that list is the reason he finds a place, my Lord, because his influence, if I can use that word, cuts across communities. So and we would.
And you have been environmentalist.
Yes, he's a college teacher, assistant professor.
Social worker, or some head of some NGO that's respected. No.
This is an assistant professor from Anthony's College, Your Lordship. That is what we
Doesn't matter.
got. He would be an independent person, Your Lordship, neutral in all counts. But
no, you see, an
the
independent person should be able to, to assist the committee in not only in one aspect only of his expertise,
Education.
but looking at the entire, spectrum of, what are the issues and claims that are involved there, and how you can work on SOP.
This was
The thing is that this is only to try to work on SOP because there are some issues with these, what they call it, district tourism committees or something like that. See what's been
I
done
think
in
we'll try
the
and get somebody
thing.
from the tourism.
Tourism is already part of the proposed committee.
No, we're talking about some, social,
activists.
a social.
Because Your
worker.
Lordship had said not a social activist or something. If I-
No, not social activists.
From somebody from the NGO, Your Lordship.
Yeah, who's neutral, who's known.
He would have been neutral, Your Lordship. But anyway, Your Lordship, if Your Lordship feels that we should suggest some
Even
other
the
names.
general. I just note down the names suggested
Names, though, I'm not sure.
today by the petitioner and by the state respondent seems to be inadequate to bring about a more comprehensive
List.
comprehensive list. They are directed to furnish more names. Yes, just after 1 week.
Oblige, Your Lordship.
Obligation.
Item number 2.
May I please, Your Lordship? Your Lordship, I pray for some more time, Your Lordship, since the conducting council is out of station.
For 1 week, Your Lordship.
Hold Your Lordship.
Mr. Longclaw not here.
He's out of station. Your Lordship.
We had reached somewhere in this hearing, correct?
Yes, Your Lordship. Your Lordship has called for records of the former suit.
No, we don't need it. What's your name?
K. Khariam.
K. Khariam? Yes. Mr. K. Khariam. Pray some accommodation as the Irving Council is to your station. Just after 1 week, yes.
Hello, Your Lordship.
Item number 3.
Today is fixed for appearance of the legal heirs, my lord. On the last occasion, we had filed an affidavit of service. So that it appears nobody has
Give
appeared.
one more opportunity.
My lord.
The next date, then we can go ahead.
Yes.
Yes, though the legal heirs of late Srimati Nehar Prabha Deb have been served and today is fixed for appearance, there's no appearance that we have as yet. Stop. Next one. In interest of justice, this matter for 2 weeks. For the appearance and for further orders.
Item number 4.
It will be uncontested only. Yes. Yes. So this is.
May it please, Your Lordship. So respondent number 6 has filed the affidavit yesterday.
Your Lordship, I'm for 4 and 5. I'm praying for 2 days' time, Your Lordship. We had sent to the commission for signatures. Lordship, I'm praying for 1 week's time.
The pension matter?
No, regarding this reservation matter in service.
Combined quota reservation quota than 5%.
This is for the post of MCS, Your Lordship.
MCS.
Okay.
And in the said process, they have challenged my appointment also.
You already been inducted now.
High Lordship, because that the other 5% within that 5%.
You already filed your affidavit.
I filed my.
It's today. This one.
Yes, Lordship.
6.
Yes.
Yeah, Kaveri Rabha. Yes, MS Karvanlang and MS Salu pray for around further 1 week's time to file affidavits. Expected next date, affidavit should be on board. Yes.
Highly obliged.
5.
Expect next date the affidavit should be on board.
May it please, Your Lordship. Your Lordship, I'm praying for further 2 weeks' time to
Where's the
file
petitioner?
affidavit.
Mr. Yubin is sleeping.
I'm sorry
Yes.
for that. My lord, they are yet to file their affidavit, my lord.
How many times you've taken?
This is the third time. Your
Third
Lordship.
time. Yes, 2 weeks further time was paid out for affidavit. Expected next date affidavit should be on board. Yes.
All right.
Item number 6.
May it please, Your Lordship. Your Lordship, I'm preparing for respondent number 3 and 4, Your Lordship. In this case, I humbly pray for some more time to file my affidavit, Your Lordship.
respondent number 5, Your Lordship. Respondent number
You file affidavit.
I need more time, Your Lordship.
What's the matter about?
This is with regard to village darbar, convening of village darbars.
Non-convening of village darbar.
Because they have listed the names, but some of the petitioner name are not listed in the electoral
But
list.
that's not been addressed. That's been,
This is that matter where the headman has generated his own list.
but that's
for the
already been
purpose
disposed of, correct?
No, Lordship.
Mr. Chakresu's matter, not the one that it was already
This is the second petition, Lordship. In the previous one, for the convening of the Darbar by allowing all the adult members to participate. But here, Lordship, what he has done is he has generated his own list.
Okay.
And
MS एक खर्ची and 2 and 4 and F खर्ची for 5 brief for the 1 week's time.
2 weeks, Your Lordship.
2 weeks time to file affidavit.
Interim order may be
Effective on
extended, Your
next
Lordship.
date. The affidavit should be on board, yes.
Interim order may be
Interim order, if any, shall continue the next date, yes.
Which one?
Item number 7.
My lord, here we are yet to file our affidavit, my lord. My lord, we have received instruction, so we have also prepared the affidavit. We just need some time to finalize the affidavit, my lord. My lord, this will be the second time we're praying for time.
Where is this?
My lord, Maxwellton.
This is Maxwellton.
Maxwellton, my lord.
Oh. As paid for a 2 weeks time allowed for affidavit.
8.
I have received the affidavit of respondent number 4 and 5.
What's the matter about?
But this is the election to the Sardar of.
So, election to the headman of Mount Krishnam.
Mount Krishnam?
Yes, Your Lordship.
Election not been held as yet.
No, Your
Elections
Lordship.
were held, my lord. It's kept in sealed cover, but in the meantime, the elections have been set aside with the district council, my lord. And
So
that
again,
is,
setting aside, you've come.
my lord.
What was the grievance? Because what is the orders? Because someone could not contest.
My lord.
Yes, Your Lordship. There was one condition imposed that
the-
those who litigate against the Lingdo cannot contest to the post of headman.
Can't be disposed of now.
Lord, district council filed an affidavit also.
Where's the council? You won't file affidavit? No. You won't file?
Smart, the matter is taken up next week. Just now I've received the affidavit filed with them. Well, our case is that the respondent number 4 was just removed, my lord, from the post of, on the allegation of misappropriation of funds, my lord.
No, but that's a condition that you are challenging. Who challenged the condition?
The respondent number 4 challenged the condition in
Your
early round of litigation, my lord.
That's closed.
Yes, that's closed, Your Lordship. And the district council was, they have passed the order dated 9 May 2000.
Elections.
No, my lord, he couldn't contest the
No,
election.
no election has been held so far since disposal of the writ that I have filed, Your Lordship, before Your Lordship.
Become very confusing, yes. Anyway, Mr. Dr. M. Modika, please was allowed to extend the file rejoinder with the affidavit filed by the respondent number 5. Stop. Mr. Hars, yes?
For respondent number 4 will be filed in the course of the day.
You are Mr.
IB Nauru.
Mr. Abhinav for respondent 4 submits that affidavit on behalf of the said respondent to file in the course of the day. Some more time.
No, we won't file.
Yes. You don't record anything. It's recorded earlier, right? Yes. Yes,
The interim order.
Interim order when he shall continue.
Hello, Raj.
Item number 9.
May it please, Your Lordship.
Some structures.
Your Lordship, unfortunately, there's some events that had happened during the pendency of this matter.
Happened?
So I pray that if I may be allowed to withdraw as counsel here.
What happened?
Your Lordship, the petitioner herein had committed malpractice.
Meaning?
He has used unfair means here while giving the exams, his third paper. It has come to my knowledge through the... So
do we close the case?
You know,
Since allowed to sit exam, nothing remains. Correct? What do you have to say?
Lordship, for the
Yes? Come this side, Mr. Lalu.
Lordship, we haven't got any instruction from the
No,
principal.
but he was allowed to sit for examination.
Yes, Your Lordship.
Exams are over.
Exams are over.
Yes, we'll close it. Pursuant to the order dated 3/6/2025, it is the court's apprised that the petitioner since sat for examinations. As such, nothing of consideration. The matter is closed. Stop. Also, another thing, Mr. Isumer, who's present on behalf of the petitioner, submits that he is no longer a counsel for personal reasons. Yes.
Obliged.
Item number 10.
My lord, this was also exam students. He has also appeared for the exam, my lord. And
We'll close it also.
my lord can be closed, my lord.
Yes, Mr. P. Ubin submits that pursuant to the order dated 9/6/2025, the petitioner has been allowed to sit for examinations. He prays that matter be closed.
My lord.
On the submissions, matter stands closed and disposed of.
Obliged, lordship.
Hearing. Item 27.
Petition. It's not there, no?
Yes, what is the case about?
Yes, Lordship. This is the petition, Lordship, where I'm asking some. I'm the not legal wife, of course, but second
You are
wife.
who?
I'm the wife of the deceased employee, actually. But then
Legally married wife.
not legally married, actually, but
Legally married wife.
yes, legally married wife.
Yes.
So out of our relations, we got two child, Your Lordship. There is I have annexes also. There is the birth certificate. That's birth certificate, and also the resident birth certificate.
The deceased employee was working where?
It's a police, my lord.
Okay.
Was working as a police in the department, and then he retired. He has taken a voluntary retired on 7 May 2024. There, after 3 days, that disease employee died on 10/5/2024. Thereafter, I have approached to the state respondent by filing my application to release some pensionary benefit, the service benefit of the deceased employee. Later on, there was no response. Thereafter, I have approached this honorable court, Lordship, and then this matter was even taken to the Lok Adalat, whereby the officials they have informed that there is another wife that is having. Then later on, then this is the petition. Now, of course, it is the fact that I'm not a legally married wife, but then it is also fact that I have been staying with the deceased employee for quite many years, out of which I have I got two
What is
child.
the age of the children now?
Now, of course, the age of the children, 21 is attained 22 years, and another is 19 years.
They're both major.
of course, they now that they are major. But they're still pursuing class 11 to 8, right? Even where we are staying together, even Rangbatong also has like given a witness that they are the husband and wife. Of course, may not Dolbar Snong also has stated that witnessing that we have been living together.
So your claim is based on?
We are claiming the based on the birth certificate and also at least that our presence where we stay, that Rangbasong also has issued a letter where it says that the petitioner herein and also the Arbat here is mentioned on 13/8/2011 he has written a letter where may I just read it, that this is certified that Miss Singchina Armarak, daughter of Srimati Prema Armarak and Sri Arbat is the deceased employee, is a resident of Lower Lumpering, Shillong 4, residing as a tenant in compound of Srimati Yolinda.
That was okay.
Yes, that was it.
Yes.
So my prayer only before this.
Where the respondents' rejections of your?
They're saying that.
Where is that?
Their affidavit in opposition. Yes, they have submitted the marriage certificate, Lordship.
Yes.
They have submitted marriage certificate.
Who submitted marriage
certificate?
certificate?
The birth certificate, the private respondent. Their child's date of birth, and they're claiming that their nominee. We are not disputing to their marriage and also their nomination, but at least before this court, at least some reliefs may be granted, because this is a fact that we become victims. At the time of marriage with that deceased employee, I was not aware that he's having.
He's not. You are not aware that he had a first wife.
He never disclosed.
Never disclosed that to you.
Never disclosed. He never disclosed. If it is disclosed, maybe I would not have involved with.
He's from Garo Hills.
Your Lordship, what he is saying is not true, Your Lordship. In para 4 of the petition, Your Lordship, they admitted that he have a wife, Your Lordship, in Garo Hills. In para 4 of the petition, Your Lordship, of their petition, Your Lordship.
Okay, no, this is only after filing after disease expired, then only we came to know. That's why we have made a mention. Otherwise, it will be like that we have concealing the fake.
No, you made when you filed this matter, you already arrayed as a respondent or was implemented later on?
You already arrayed as a respondent.
That means he knew. That means
yes.
he made you party.
Yes, after the date we came to know, we have filed at the time of filing only we have implemented them.
No, so that's fine. So what he's saying is not correct.
Yes,
so
yes.
Forget about that. That's not immaterial. Yes. Yes.
Though my prayer is that, of course,
When was this entry made in the service book? You said you're married from which year?
Yes, I have been living it. It's mentioned there since mentioned from 1999. The person that is yes. In para 2, I have make a statement.
Okay, and now this service, now this kindred role annexure 1, dated.
Annexure 1, yes, that is this annexure 1 is the birth certificate of my.
No. This is of the affidavit filed by.
Yes.
Respondent.
Yes.
Which date is this?
This date is on 16 for 1993. The year of 1993.
Where is the sign? Where can you get a date?
Lordship,
just showing that.
This in the page 10 of their affidavit in opposition, lecture 1. I think the next page 11, that is translation marriage certificate.
There's no date, okay.
There is day is 16.
This is the certificate, marriage certificate. It is dated when?
Dated, my lord, it is they have mentioned
16/4/93.
Yes, 16/4/1993. It should be 1993. Year, day 16, month 4, then year 1993.
Okay, they married in. That means he.
1993.
What is the other one? This is 1693. Whose name's Elizabeth? What's this? Sangma. What is this?
The bride's name is Salim.
Pante means what?
Pante is unmarried.
And mother? What is this? And then Silent Marak is whom? Below.
Silent is the respondent number 4, Your Lordship.
And number 1 is whom?
Number 1 is the
Albert, Your Lordship, the deceased person,
actually,
Your
but
Lordship.
the name is not correct actually. Here they have mentioned Ilbert. Actually, that should have been AL.
Okay. Or spelling is wrong.
Yes, spelling is wrong.
Okay. This is.
But in the birth certificate, in the name, there also they have some mistake. But this also Albert actually.
So 16/4/93 is the marriage certificate. It's issued by whom?
It's issued by priest.
Issued by the church.
Okay.
Issued by the church.
They had a child that was born in 94.
Yes. They have a child born on 1995.
7/4/94 in here.
Yes.
Okay. That means delivery from 99. So
Yes,
99
yes,
that
99.
means okay, the dates tally then.
Yes.
Yes. And what's your affidavit? What do you have to say?
Saying they don't know.
Your Lordship, if we come to their prayer, Your Lordship, in their petition, Your Lordship.
What a prayer, whatever it
Yes,
is.
Your Lordship. They prayed for 50% share of family pension and other retirement benefits to the petitioner, which she is entitled as per the Meghalaya
So one
pension
thing
rule.
that did the husband didn't stay with you after 99?
He's staying with me.
He died in whose house?
In the respondent number 4's house, Your Lordship.
She looked after the funeral rites.
Yes, everything, Your Lordship.
Last rites.
Yes.
He died in Garo Hills or in Shillong?
In Garo Hills.
The hospital actually.
In Garo Hills?
In Garo Hills, in Garo Hills.
But then you stayed in Lumparing, Shillong?
Yes, Lumparing, Shillong.
But he went back there?
He went back there. After taking the voluntary retirement, he went back there and he died in the hospital. And then
Your Lordship, that's not true. The petitioner is a stranger. They never stayed together, Your Lordship.
Then how did they have 2 children?
But Your Lordship, the respondent number 4
name recorded in the birth certificate.
But the respondent number 4 took care of him, Your Lordship. They maintain a joint account, Your Lordship, in the bank.
So you also dispute this very fact. Then you have to file a suit.
And Your Lordship, in the 50%, Lordship, there is no provision, Your Lordship, under the Meghalaya civil pension rules, Your Lordship, that 50%, Your Lordship.
The other question, 50% is a question of some internal benefits also will go if the children are from the union
share.
that they are entitled. If the wife is not entitled, the children be entitled. Why should the children be deprived? Yes.
But Your Lordship, the petition is not maintainable, Lordship. There is nothing under the rule, Lordship, that a person may receive 50% share of the pension, Your Lordship.
The prayer can be made for 50%. He can ask for 60% also. Nothing to stop him making any prayer. But the thing is that, so you perform the last rites, these pictures you annex.
But Your Lordship, the person to receive family pension is only by means of nomination, Your Lordship.
You've seen the latest Supreme Court rulings with regard to the children. What entitlements? You must have seen that. Then we're looking at that only. Oh, he died in Golpara.
Yes. Died in this.
Next here, Your Lordship, is a death certificate. Page 34.
So that means that he was staying in both places same time. He was cohabiting with his first wife and with
No,
with
actually,
the petitioner also.
what I'm doing is after staying with me, he don't go to college because he was posted here only, and he has been staying. And the first wife he might have misinformed the first wife that might be staying somewhere in the quarter, but actually she was from the
only
day.
case you have, Mr. Samar, that you had two children from the whatever from the relationship you had.
Yes,
with the
and
deceased
and
wife.
Rangbashnong also they have
Rangbashnong,
of course they have witnessed my staying together. No, we are not insisting for any 50% or at least some.
What? Yes, Mr. Kharmi, you released terminal benefits or still?
No, it has not been released to anybody.
He died since 24.
Yes, he died.
What is the total dues getting? Which is all his other, I mean, his term benefits amount to how much? Leave aside family pension?
That one, I don't have any information.
Otherwise, we'll pass on order. You make some payment to the petitioner.
Who took care of the husband? Lordship, only two of them will be able to tell, because the private respondent is first wife, and the petitioner is the second wife. And from the second wife, there are two children.
Yes.
There are two children, and
so what was happened? He was posted here, so he married not married. I mean, cohabited with the petitioner.
after he met the petitioner, they were living together, husband and wife.
No, but then he died. But then I could understand if he stayed with till the end. But then he went back to his first wife.
Yes, Your Lordship. Even medical.
So you were not aware that he had a second wife in Shillong?
No, Your Lordship.
He never told
No,
anybody.
Your Lordship.
So till death, you're not aware.
Only when we approach for the pension.
No, but he said that he weren't allowed to go near the funeral.
Your Lordship,
He
that's
he
not
didn't
true.
come to take part in the funeral.
Your Lordship, they're not even aware, Lordship, that he passed away, Lordship.
No, we
was not aware he passed away.
The petitioner.
We know, Lordship, at the time when he was there.
See,
Now,
this
even
is
the
more of a mercy petition. We're not going on law exactly. We need that only to get the facts straight. Because otherwise, you cannot establish it. Then you have to. Yes. What law you want to place?
no, yes, there is a judgment court also is a Lordship. This is.
What judgment is that?
Yes, this one is there.
We'll hear you also. What you want to read the Meghalaya Civil Service Pension Rules, Rule 48.
Yes, Your Lordship.
Yeah.
And this one is. That is.
Only thing they're not minor, no? That's the only thing.
Para 2 is there. Judgment.
When he died, your children were minor, no? One of them was minor.
Yes, one is minor. Page 433, para 2, the para 3 is there, Lordship.
Because the only thing in favor is that you have this birth certificate, but it's of that person itself. He's
Yes.
Albert Sama.
Yes, it's not disputed. It's from Albert Sama.
The presumption of marriage will go in your favor. But only thing is, your children are major now.
But they are still pursuing the.
What paragraph you want to read?
Para 3 here, there are many stated, but here it is.
Yes.
So may I just read it? Para 3, the dispute concern payment of family pension and death come retirement gratuity. Two wives of Narayan Lal who died in 1987 while posted at Managing Director Rural Development Authority of the State of Bihar. The appellant is the first wife. Narayan Lar is stated to have married the second time to Yugmea DB on 10/4/1963, while the appellant was still alive. From the first marriage, he had one son, and from the second marriage, 4 sons born in 1964, 1971, 1972, and 1976. Learned Singer judge in his judgment held that children born to Narayan Lar from the wedlock with the Yogmia DB were entitled to share the family pension, and that come retirement gratuity and further that family pension would be admissible to the minor children only till they attain the maturity. He also held that the second wife, Yogmia DB, was not entitled to anything. Appeal by the first wife, Resmawari DB, against the judgment was dismissed by the division bench. According to her, there was no.
Okay. Yes. That's the only judgment we have.
Yes,
Yes.
yes.
What? You
Your
repeat the
Lordship,
rules.
Your Lordship, the children of the petitioner had attained the age of majority.
Yes,
Your
fine.
Lordship.
You wear the rules. They are not entitled to family pension since they attain majority. But if we can find out a way that at least some amount, you pay her some amount. We want to know, Mr. Harmi, how much you get the total amount what she's supposed to get, all the term benefits. Then you give her something. That's all. It will not be a precedent, but then see, being major means suppose a minor, the court can order straight away that they'll be entitled to a share of family pension till they attain majority, right? But in this case, the thing is that they're both already majors, they are still dependent. So we're just trying to work out a balance, because whatever it is, if he's cohabited, their children are there, whatever she's in, it's just on humanity aspect, not on
If
the legal
they
aspect.
give
Yes.
something also, I will accept, Lordship. At least should be some reasonable. We are not
We have to
insisting
know,
also.
Mr. H. Karmi,
Lordship, okay, I have
yes,
got
what do you want to say?
3 judgments that I would like to rely on.
What judgment? What does it say?
One is that in that same judgment relied by the petitioner Lordship, in that is the first wife, she's challenging the claim of the second wife to the family pension and service benefits of the husband. So the High Court held that the children of the second wife, being the legally the legitimate children of the deceased employee,
Not they legitimate, but they're entitled. Yes. And in our for them, for Meghalaya as matrilineal, there's no, they are considered legitimate. There's no legitimacy in the society because they take the name. So fine. So that's it. The fact that she does not deny that they're children. No? She doesn't deny. Only thing is that she's the nominated. She's a nominee. Yes. That's the thing.
And the DB also upheld the judgment of the single bench that they are entitled. And they went on the Supreme Court. The Supreme Court also agreed and held that.
No, that is the law now. Only thing is that they are major. So family pension we can't give orders, but then just find out how much amount is there. Then she'll let her part with a bit of it.
And it's the same.
Since we send mediation, you refuse to consider, correct?
Your Lordship.
Yes. Look at the mediation.
Supreme Court and one is from Andhra Pradesh High Court. This is also both the wives are.
No, this law settled that. Yes, Mr. H. Karmi, Leonard, Additional Senior Government Advocate, directed to obtain the exact amount of term benefits due to the deceased employee, apart from family pension. Payable. When can you bring this instruction?
2 weeks, Lordship. 2 weeks.
Yes, after 2 weeks. Then that time some amount you give them, then that will close the matter.
Yes, Lordship.
29.
Yes, Lordship.
Yes. For the other one's gone, it's gone ex parte.
Ex parte, Lordship.
Mr. Philemon's appearing for whom?
For
For the bank.
Respondent number 5.
Then no one. When was this affected? Notice was affected when?
Lordship, order dated 18/3/2025.
You ready the matter today?
Yes, Lordship. 18/3/2025. Proceeded ex parte. Respondent number 6 and 7.
What is the fact of service here?
18/3/2025.
Exactly. 6 and 7.
Affidavit. There are 5, 6, and 7. Or they are response number.
Respondent number 6 and 7.
एक टिश्यू लो वो बड़ा वाला टिश्यू
Lordship, here the bank Shillong Cooperative Urban Bank Limited is the petitioner, Lordship.
5 is whom?
5 is Secretary Muda, Meghalaya Urban Development Authority.
Okay.
1, 2, 3 and 4 is represented by state.
Yeah.
Council. So bank had been functioning since 1959, Lordship. So
Once
in the year
checking affidavit of service. Wait.
Yes.
Just easy with the argument. I'm just checking the affidavit of service.
No, there is a prayer against you.
It was put in the paper also?
Not paper, Lordship. Dasti. First by registered post, thereafter it was by Dasti service.
So yes, received 11/2. Yes, before proceeding with the hearing, it is noted that this court, by order dated 18/3/25, had directed for ex parte hearing against respondent 6 and 7, as in spite of receipt of notice, they have not appeared to contest the case. So, a perusal of the affidavit of service, next paragraph, shows that the respondent number 6 had received notice on 11/2/2025, so also the respondent number 7. So, start then. Yes. Yes.
Lordship, the bank.
Yes.
The bank is registered under the relevant provision of cooperative societies, as amended from time to time, by registration number SIL 51, dated 1st June 1959. It is stated in para 1 of the petition. So bank has been functioning, Lordship, and by letter dated 5/12/2011,
yes,
Lordship, the bank had approached the office of the Deputy Commissioner with an appeal that the bank be provided with a vacant land at Rinja, Lordship.
Yes.
And bank had gotten RBI license to run the branch at.
Okay, fine. It's a cooperative bank. It's got all the necessary, permissions and all. Yes, continue. Come to the main point.
Lordship. So thereafter, Lordship, the letter application was considered.
Where's the application?
Application it at Annexure 3 is the application. Allotment of a plot of land at considering that application, Lordship, by Annexure 4.
Yes.
That is communication dated 21st March 2012. The respondent number 4, Additional Deputy Commissioner Revenue, had forwarded a copy of a sketch map showing a vacant land to the bank.
Annexure 4.
Annexure 4.
Yes. Then what happened?
Thereafter, Lordship, by letter dated 29, Annexure 5. The Deputy Commissioner has recommended, had written address to the Under Secretary to the Government of Meghalaya, Revenue and Disaster Management, has recommended for grant of necessary sanction and approval from your end on payment of premium.
Let's see the
Annexure 5, page 44.
Page?
Page 44.
Yes. What's the size of the land?
Size of the land is 175 square meter.
Transaction approval and premium also 2000. Right. Okay. Yes. Then.
Lordship. Thereafter, Lordship, Annexure 6.
Yes.
Dated 27 January 2000. This is from the Deputy Secretary to the Government of Meghalaya.
After 2
Revenue
years. Then.
Yes. That was in this connection you are requested to examine the matter of revision of rate of premium and land revenue and calculate the premium. So accordingly the premium has been recalculated, which is at page 46-47, and the payment has been made by 2 checks.
When was
it is at page 48, Annexure 8.
Then page 8.
48,
Page 48.
Annexure 8.
Premium.
Premium of cost of premium on land and cost of land revenue paid, Lordship.
Yes.
And thereafter the Additional Deputy Commissioner had deputed from the office for demarcation, survey and demarcation of the land at page 49, Annexure 9. Now premium has been paid, Lordship. Additional premium was also required because there was some extra land was there, Lordship. So the page 51, Annexure 11. So for the extra land also the premium has been paid by 2 checks. Thereafter steps were taken for construction of the bank building in the said plot of land.
Vacant plot.
Vacant. The handing and taking over of possession is at page 13.
Page?
Page 53, Annexure 13.
Okay, handing over.
A certificate of handing, taking over of possession of the plot of land. Lordship. 2nd July 2014.
Yes.
Thereafter, bank has taken steps for construction of this, and to this effect, the bank has approached the MECL Shillong for construction of the building at Rinja on turnkey basis. So that communications we can skip, Lordship. And then for construction of the building, Lordship, the form has to be countersigned by the respective Ramashnam for obtaining the permission, Lordship.
Yes.
So that was not done. Therefore, the White Annexure 19, page 60.
Yes.
The Secretary of the bank, who is now the CEO, Chief Executive Officer designation has changed, had written to the Rangmashnam, Rinja, Shillong for issuance of NOC.
Yes.
For construction of Shillong Cooperative Urban Bank at bank premises as Rinja. There is a plot 52 measuring an area of 220.84 square meter, more or less. After receiving this letter, Lordship, on 10th of October 2024, the respective Darbashnong has Executive Committee of the Darbashnong has written to the Deputy Commissioner Revenue East Khasi Hills that it has come as a surprise for them. This letter, may I read, Lordship?
Yes.
With reference to the subject above, we are to inform you that the Darbashnong Rinja has received a request from the Shillong Cooperative Urban Bank Limited, white letter number so and so, for issuing an NOC to enable the bank to construct a building at plot number 52. The request has come as a big surprise to the Executive Committee of the Darbashnong Rinja, since the referred plot, as mentioned by the bank, is within the land which belongs to the Darbashnong. Necessary particulars along with vital documents pertaining to the land are enclosed herewith for your kind information. And the Executive Committee had also written to the Secretary of the Shillong Cooperative Urban Bank, that is at letter dated 17 October 2014, Annexure 21, page 62. And they have that the land, in support of that, they have enclosed two documents, that is Annexure 22, page 65.
Now we see that they use NEC funds to make a playground there.
Yes, Lordship. But that particular plot is not used. That plot of land 52, it is a vacant land, Lordship.
How do we know? How
even now also it is
here that's not been used.
Because from the record only itself it will speak that the land is vacant. Now after this, Lordship, we have approached the respondent number 3 and 4 continuously for peaceful possession of the land so that the bank can construct its own building. Now during that time COVID was in its spike, so the matter remained still for some time, and again we have taken up the matter, Lordship, and there was subsequently meetings were held in the office of the Deputy Commissioner, where all the parties were present. That Lordship may come to Annexure 2978.
You asked for refund. They refunded the amount?
No, Lordship. Not yet.
So are you interested?
That we have also.
The bank, you're not interested anymore.
No, bank is interested, Lordship. Bank is interested for having an office. If this is a hurdle for the state or the government, the government can provide a alternative land also.
Yes.
With this. So thereafter, Lordship, nothing has done.
One second. What is this Annexure 29? You said
29 is the letter for meeting in the office.
Meeting was held on Annexure.
Meeting was held on type copies page 82, 19 August 2016.
Like page 79.
Yeah, yes. Page 82 is a type copy. Member presents at the meeting for the plot of land acquired by the Shillong Cooperative.
Alternative plot.
Yes.
So you agree at the time to take an alternative plot, right?
Yes, Lordship. That Lordship. Thereafter, the legal notice was also issued to the bank. A comprehensive representation was also
issued to the bank.
No, the bank has submitted a comprehensive representation also, and thereafter, Lordship, bank had issued a legal notice to the respondent number 3, 4, 6 and 7.
They replied?
No, Lordship. No reply has been, and further a communication was forwarded to the bank. A copy of the communication made by the Additional Deputy Commissioner Revenue dated 25th May 2023, which is Annexure 38. So the
now in 2019, this Annexure 32 yes, state.
Lord, presently, they are not really interested in an alternative space. They are insisting that they be given this space. So that is their prayer, Lord. They're asking for handing over of peaceful physical possession of plot number 52. They are not looking at any alternative space. As far as we are concerned, Lord, we are taking the stand that the Dorbashnong was never allotted the property. They were permitted to use it as a playground. This is a case of a private dispute between both these parties.
Why
we don't have a position. We are not in a position to recover the property from anybody.
Why?
We'll kindly see.
Is revenue paying land correct?
Yes, my lord.
Then
please see the handing over. There was no dispute at the time of handing over, which is at page 53.
No. That we cannot accept.
We are not in favor of anybody coming and interfering with this property. We've rightly handed over the property to the bank.
You can't expect them before even they put, they put a foot in the door that they involve a title suit.
No, absolutely.
Yes.
Please see page 53. This is that handing over, taking over. Please see at the bottom. Handing over was done by the DC on 2/7/2014 and the taking over was there.
Yes.
The interference, there was no physical interference as such. As far as the interference is concerned, for the first time, please see at page 61, there is a letter issued by the Executive Committee of the Dorbashnong.
Right, we've seen that.
What they are simply saying is that the plot is under litigation. That is what they have said. We don't know. This is what they are saying. The Dorbashnong is claiming this.
They have not come forward.
They have not come forward. They have not come forward. Then
we will direct you to go and fence it and hand it over to them.
Lordship. And just please see their letter, my lord, at page 89.
Well, wake them up. If they don't reply, you go and fence it and then hand it over. Yes.
So at page 89, my lord, see, this is a letter dated 17/9/2020. The subject is dispossessed from government allotted land, prayer for restoration of possession of the land covered by plot number so and so. And please see page 91, the third last paragraph.
Now these whoever drafted this is not.
No, I'm not questioning the drafting at all, my lord. What they're saying is it has now been brought to our notice that the Rinja Dorbashnong has very recently erected a signboard in the said land which reads as property belongs to Dorbashnong.
Allotted to them. Which annexure was that? When it says allotted to the Dorbashnong, which annexure?
Just a moment. Page 65, my lord. Letter dated 9th June 95. Again, my lords, I would say it is not a case of allotment.
65, yes. This is important. 65 is a type copy.
At page 69 is the no, my lords. 65 we've not supplied any type copy.
No, okay. 65, you want to play playground. Okay, fine.
The government-wide memo number so-and-so has no objection for establishment, construction of a playground at Rinja by the Durbar
Where's
Shah.
this government-wide memo number? Where's this, sir?
Have you endorsed that letter? This 5695, just check.
We'll know the exact genesis. Or what kind of possession was given to them.
Lordship.
See, even the deed declaration fight, see, how have they made a deed declaration also?
Lordship, we've seen that.
But not registered, correct?
No, this appears to be registered, my lord.
Yes, RP Marak.
Then, Manoj, I'll take instruction on this particular letter of
Get this letter.
5695.
Yes.
May come up next week.
Yes, on the course of hearing, it is noted that
this letter.
With regard to the plot of land in question, which has been allotted to the National Bank, the respondents number 6 and 7 do not represent it from materials on record shows that they claim to ownership and possession is on a basis of a letter white memo number state down number RDS capital stop 22 stroke 95 stroke 2 dated 5th June 1995, which is also mentioned in the deed of declaration made by the headman of the respondent number by the respondent number 6 on 14/7. What's the date? Where the date 14/7/95. Next parameter is the government is directed to obtain a copy of the said letter to establish a factum of allotment. To establish whether the land was ever allotted to the respondent 6 and 7. This after 2 weeks. Copy of the order be made over to the government advocate for onward communication. Yes.
Lodge.
Once that comes out, if that's not there, then we'll ask to be fenced. And you can't just occupy government land like that.
30?
Only authority of lawyers.
30?
Yes, ready, Mr.
Please, Lordship, senior counsel is on next, Your Lordship. So, Lordship, I pray that this matter may come up after 2 weeks.
And the board.
2 weeks, Your Lordship. Accommodation. 2 weeks accommodation, Your Lordship.
You're a German specialist of a chamber? No. He's a German specialist, yes. After 2 weeks.
Lordship, interim order to be continued, Your Lordship.
Then interim order will be vacated. Correct.
Let it
you
be
know the
wa-
matter. You have the brief with you.
Lordship.
You read. You can read it. You can read it. What is the matter about?
Lordship, this is regard to VC, Your Lordship. Election to
Because
VC.
here election was held, that the result was State Lordship. And
It has gone very urgent. When was the result? When was the election held?
November, Lordship.
When was the result declared?
Result declared on the same day, Lordship.
See, you should take the opportunity. If your senior is not there, you argue in the matter. If the order will go against you, we won't pass orders. If we succeed, we'll pass. You take opportunity.
After 1 week, Lordship. Then.
After 1 day?
1 week.
Okay, 1 week, yes. Interim order till next date, yes.
31?
It's 30 and 31 connected, Lordship. Must.
Should always take, see, juniors should always take advantage. Because I always encourage our juniors to argue.
True, Lordship.
How do you develop then? Soon you have to take away all the seniors' briefs also. Correct? It's like Miss M.R. Marak will take out Mr. Sheikh's briefs. Yes.
Master.